As such, the Chief Engineer Irrigation by order dated 16/03/2023 suspended him from service under the provisions of Rule 6 of the Assam Services Disciplinary Rules 1960. After his release on bail in said SCPPS case number such and such, petitioner Mr. Saranya, when did you issue that?
Matter 16, my lord. 16-3, my lord.
No. When did you submit this?
My representation, my lord.
Yes,
3/7/23.
7/2023 submitted the representation.
Yes, 23.
Chief Engineer Irrigation or revocation of it. On instruction. Though his representation for revocation of his order, of suspension, that is 16/03/2023, has not yet been considered by the said chief engineer. Hence, on instruction, Mr. Upaita extending council irrigation submitted that on 29/08/2023, after the submission of the representation by the petitioner on Saturday, show cause notice was the petitioner for the 11 charges, the list of documents, list of witnesses, the 11 charges, fixed statement of allegations.
Means he seeks time for lordship to reply the
The
charges.
petitioner on 05/09/2023 prayed for 15 days time to submit. The contention of the petitioner is that following the judgment of the Honorable Supreme Court in the case of Ajay Chaudhary of the circumstances, the interim order of suspension from service dated 16/03/2023 is not maintained accordingly, as it has left it should be reinstated in service. In terms of the judgment of the Honorable Apex Court in the case of Ajay Chaudhary, show cause notice to be issued to the concerned employee after placing him at suspension within a period of 90 days from the date of representation / application after releasing him of the car on bail from judicial custody, bail release. Mr. Upadhyay submit. As he submitted a representation on 03/07/2023 after being released on the and since so called notice was issued to him on 29/08/2023, it is much within the time of 90 days. However, the respondent authorities in the irrigation department failed to place anything before the court regarding the review of regarding its review pertaining to the order of suspension to place the petitioner, like allowing the petitioner to remain in suspension. After considering entire aspect of the matter, the said petition is disposed of the direction to the chief engineer irrigation department to dispose of the representation of the petitioner dated 03/07/2023 in accordance with law. More particular, if the authorities concerned during the deliberation finds that there was no such review regarding keeping the petitioner under suspension after the order dated 16/03/2023 and after 03/07/2023 after the representation dated 03/07. Shall consider to reinstate the petitioner in service. However, it is made clear if the authorities concerned decides to raise the petitioner in service subject to the review of the order of suspension for study. In time. The authorities concerned will be with the liberty of the authority concerned to decide his posting as so cause notice has already been issued to him on 29/08. The chief engineer irrigation department shall communicate its decision to the petition.
7 days, my lord.
On or before the 31st of October 2023.
My lord. On or before, my lord. On or before.
31st of October.
How like that?
It is so long, my lord. Already, my lord.
You see the action, Mr. Sadania.
My lord.
So
I have.
it is better to keep quiet and get a favorable order in your favor.
How like that?
I love you.
No representation on behalf of the petitioner and the public. Even on last occasion, I use 08/09/2023. The petitioner remained list after it made it.
Your Lordship. Lordship, matter relates to non-payment of incremental benefit of the petitioner, Your Lordship. Petitioner is initially appointed as assistant registrar under OBB 4040 scheme, Your Lordship. Thereafter, his services was regularized. Subsequently, regularized was cancelled, Your Lordship. Several petitioners, several similarly situated persons have challenged the aforesaid cancellation order, Your Lordship. A petitioner also filed a petition against that cancellation order. Subsequently, Lordship, that cancellation order was withdrawn and his services was regularized by order dated 3/5/2011, Your Lordship. Thereafter, he got all salaries, etc. But the incremental benefit with effect from 1/4/1999 to 30/6/2019, amounting to rupees 11,06,350, Your Lordship. That is not paid to him, Your Lordship. Your Lordship, similarly situated persons have got order from this honorable court. That order I have annexed, Your Lordship. Annexure 10, page 58, Your Lordship. Lordship, my prayer is that the petitioner case is also covered by this judgment, Your Lordship. By Annexure 7, Your Lordship, the district elementary education has written to the Director Elementary Education that is to take necessary action for release of incremental benefit, Your Lordship. That is Annexure 7, Your Lordship, page 55. But till that he has not got, Your Lordship.
Please take your seat.
Mr. Khatmi,
Yes, ma'am.
please come to page number 53.
Page number? Hello? What page?
53.
5. Yes, madam.
Before the decision,
As per recommendation. As per recommendation of the Aforesaid Committee, Finance EC3 department was moved and the Finance EC3 department has vetted the draft speaking order and conveyed no objection for awarding past service benefit, pension benefit to 2044 numbers of OBB teachers among the group of 4040 numbers of OBB teachers across the state in compliance with the Honorable High Court's order dated 19/5/2015 passed in WPC number 3058/2011. Why dear so and so dated 8/2/2019. Further, Pension and Public Grievance Department conveyed their views wide under note number so and so dated 27/9/2018 that for counting the past service of the OBB teachers under Rule 31 of Assam Pension Services Pension Rules 1969, the invoking of the rules does not appear necessary in the instant proposal for the time being.
What is the division bench judgment in district?
In respect of
There are two with regard to the regularization of service of the OBB teacher. Division bench judgment is there, reported in the jail. Are you aware?
no, madam.
Yes, Mr. Purakash, what is the judgment? Division bench judgment.
OBB teacher division bench.
OBB, that is, that case I have not done, madam.
You're not aware.
Not. AM board will.
সেইটোতো বেলেগ সেইটো এতিয়া হৈছে আগৰ
Mr. Patani, State of Assam versus Nirmali Bora.
নিৰ্মালী বৰমালী
2008 GLP.
Milo 548
543.
5 foot 3 5 foot 5 foot 3 by এইটো নিৰ্মালী বৰা 2005 8 GLD 543 নিৰ্মালী বৰা পাম লাইনিং বৰা business person যেতে পারবো Hmm? Well, here in the original regulation order in the 2011, madam, there is a condition for the incremental benefit, madam.
Just Or MSR data council appearing for the petition. Mr. Katnier,
Yes, my lord.
for regularizing this OBB 4040 and OBB 7066. There are a class with the drop details.
Yes.
So in a division bench, the state government placed the details for all the districts of the state of Assam at that point of time. Probably it is in Manoj Kumar Shah.
No, no, sir.
Probably. Forgot. The list, the detailed list was given, district, the name of the 4040 tickets, including the name of the 40. It was not 4040, ultimately less than half.
Yes.
Because many of those teachers serving in fixed pay under OPB 4040, the district elementary education officer or the director has passed some order, so they got adjusted in various schools. So the detailed lists are available. It was given by the government, and accordingly, court allowed, because there is a huge number of drop teachers as well as 4040 as well as 706. Big exercise was carried out. Now, initially they were not against it, any such substantive post.
Yeah.
So they have been adjusted against the substantive post in terms of the order. Now, one of the matter where Mr. Shantanu Das was the counsel for the response.
Yes.
The detailed report he will be knowing. Detailed report is there. Of course, whether these are considered or not in the subsequent orders, we do not know. But he dealt with the matter. The decision was of the court was that only when they will be considered against the substantive post, the benefit to be given to them. So, notional benefit was given to them,
Yeah.
but not such financial, because there was no such claim regarding their financial claim. They approached this court only after their regularization in sum.
Yes.
Because after their regularization, they have gone into the substantive court. So, only with the approval of the court, they were provided with the substantive court. Their services are regularized. Now, after regularization, they started claiming their whatever benefits. Because till then, there was no claim by the petitioners. Anyway, this order has been passed at this stage, we do not know what circumstances government have passed that order. We'll issue notice at this stage, but nothing else.
In this particular case, my lord, there is a condition in the page 26, the regulation order, that they will get the annual increment only after completion of the junior basic training, my lord.
Has it that training he has completed, your lordship?
What
I
is
have
the question of
instruction that.
junior basic training?
Page 26, my lord.
In fact, the respondent authority also admitted that he is
Question of junior basic training doesn't arise with regard to an ME school teacher.
Sorry, my lord.
Question of junior basic training doesn't arise with an ME school teacher.
But here there is a condition, my lord.
It should be diploma in elementary education.
No, my lord, yes, it's a senior basic, my lord. I'm sorry, my lord. The word used is senior basic.
Senior basic. Normal training. Yes, Ms. Decker, whether the petitioner has undergone the training?
Yes, your lordship. As per my instruction, he has undergone that
When?
training.
That statement is not in the petition, my lord.
When?
Lordship, I will take that instruction, your lordship.
You should have annexed a copy of that order by which the petitioner
Yes,
has passed the junior basic or senior basic training or the diploma in elementary education.
Yes, I will do that. Your lordship.
You better file an additional affidavit to that
Yes,
extent
sir.
in that case. Petitioner is allowed to file an additional affidavit. annexing the copy of his passing the senior basic training public normal public diploma in elementary education. For getting benefit in terms of the order 11/2012, no, 26/03/2013. The petition, annexer 3 to this. Place this matter for motion. Filing such petition.
Oblige Lordship.
Yes, Mr. Das.
So, Malad, non-payment of Malad, compensated pension and the service benefit of the petitioner. But the husband of the petitioner was died. He was a regular assistant teacher of a school, Malad. He was died at the age of 55 years. Died on 4/10/2022, Malad. And till then, no pension, nothing of the sort was given to the wife of the deceased husband. Page under page 29, government notification. Malad.
When did you apply?
Malad.
When did you apply?
Formal application we have furnished and last Malad, page 32 is my representation. I have filed it. And the procedural application has been furnished to the authority. Malad. Immediately after his death.
When his service was regularized,
The page 22. Twenty-five 10/2020. I am number 1.
Mr. Khatania, there is an appropriate application for filing such, taking the benefit of compassionate family pension. What was his age at the time of his death?
55 years.
But D.K. Das, learned counsel appearing for the petitioner, and Mr. N.J. Khatania, standing counsel, Department of School Education.
For 1, 3, 4, 5, and 6.
On the numbers 1, 3, 4, 5, and 6. So have standing counsel AG Assam protest number 2. Husband of the petitioner, Manik Dutta. An assistant teacher at Potoha Paligaon Lower Primary School under Porvolva Education Block, District Dibrugarh. Harness on zero 4/10/2020 leaving behind the petitioner his widow and 3 daughters, of which the youngest one minor. It is stated that at the time of death of her husband, he was of 55 years. And her 5 years of service in his career. Petitioner applied for the benefit of compassionate family pension on 28/10/2022. However, the same has not yet been considered by the respondent authority. Being agreed, the petitioner has preferred. The state government in the finance within bracket establishment as a department by notification number FED.28/2017 of dated 14/09/2017 with effect from 01/04/2017 brought into force the benefit of compassionate family pension in lieu of compassionate appointment with regard to the government employees who dies in harness. The said compassionate family pension lays down certain criteria towards entertainment of benefit of such pension. The after hearing the letter counsel for the purpose, this petition is disposed of, directing the petitioner to submit a detailed representation along with the death certificate, copy of the death certificate, copy of the next of kin certificate. The petitioner has annexed a copy of the death certificate of her husband dated 13/10/2022, issued by the registrar in bracket Bartlett, Borborough Primary Health Center. Next of kin certificate of her husband reflecting the name of the petitioner and their voting office, issued by the Office of the Deputy Commissioner, Dibrugarh, on 10/01/2023. As well as a certificate issued by the village headman, government village headman, of Gandhinagar, Ward number 2, of Gandhinagar, Gaon Panchayat, Ward number 2, which present petitioner is residing with her daughters after date this photo of the direct petitioner to submit a detailed application before the Deputy Inspector of Schools, Dibrugarh, on or before 6th of October 2023, along with copy of the death certificate, self-attested copy of the husband, self-attested next of kin certificate of said late delivery Commissioner Dibrugarh on 10/01. Obtaining necessary acknowledgement of the same. Thereafter, the Deputy Inspector of Schools, Dibrugarh, shall duly process the same, obtaining necessary report from the Block Elementary Education Officer, Borborough Block regarding the service of her late husband. Right. Now, assistant teacher of Kotoka Baligaon Primary School, who died on October 14th, and shall submit the same. And after getting the certificate, shall submit the same. Director of Elementary Education, 30/11/2023, who in turn shall process the same with due approval of the state law, the Department of School Education, the finance. If the petitioner is found entitled for such compassionate family pension, the entire process payment of such family pension to the petitioner shall be completed by the respondents in the Department of School Education, including the Director of Elementary Education, the Deputy Inspector of Schools, Dibrugarh, as well as the Block Elementary Education Officer for Borborough Education Block, will have finance department on or before 31/12/2023. The above application is
Obliged.
Yes, Mr. Busso.
My lord. My lord, the petitioner is the block project officer appointed under project, my lord, appointed by in the year 2019, by annexure 1, my lord, at page 16. On contractual basis, my lord, for a fixed salary of 15,000, my lord. Now, kindly see the impugned order and next page, my lord, page 17. He was transferred from Jala to Godeswar, my lord. My lord, now what is the difficulty, my lord? He is the caregiver. My lord, may come to page 18. Page 18. His brother, Noyan Haloy, is a mentally ill person, my lord, with 60% of disability. And his parents are also ailing, my lord. And he was under leave, paternal leave for the newborn, my lord. Now, the respondent authorities not insisting the transfer order nor any handover of charge order has been passed, my lord. My lord, kindly come to the representation, my lord, which is at page 28, annexure 6. Page 28, annexure 6, my lord, wherein he has stated about his difficulties. My lord, he's a contextual employee, my lord. He has been transferred, my lord, with a fixed salary, my lord. How he will be able to manage it, my lord, from Godeswar, my lord.
Question.
And kindly come to my lord. Kindly come to page 34, annexure 9. This is the OM of the DOPT, my lord, Ministry of PPG, my lord. Here, my lord, at paragraph 3, the enactment of the Rights of Persons with Disability Act 2016 on April 17, 2017, the following instructions are issued in supersession of the above mentioned OMs of event number dated 6/6/2014, November 17, 2014, and January 5, 2016, with regard to the eligibility for seeking exemption from routine exercise of transfer, rotational transfer. 1. A government employee who is a caregiver of dependent daughter, son, parents, spouse, brother, sister with specified disability as certified by the certifying authority as a person with benchmark disability as defined under section 2R of the Rights of Persons with Disability Act 2016 may be exempted from the routine exercise of transfer, rotational transfer, subject to the administrative constraint. Number 2, here, my lord, in Roman 8, the mental illness. Mental illness, number 2. My lord, here I have annexed the certificate, my lord, which is at page 18, annexure 3. His mental disability percentage is 60%, my lord. And on similar ground, my lord, this court has set aside the transfer order, my lord.
Mr. Question. The impugned order of transfer is of 31st of May 2020.
My lord, till today they have not acted, my lord, and the person who was transferred in the place of the petitioner, due to some illness, my lord, he has not joined, my lord. He has not come. My lord, kindly come to
You mentioned that you are the only person in the family to look after your brother.
My lord, I have mentioned it, my lord.
You're the only.
Yes, my lord. Yes, my
Only
lord.
two brothers.
Only two brothers, my lord.
Where you have status?
I have specifically stated in paragraph 4, my lord. That your humble petitioner Bhikshut said that the petitioner is the lone bread earner in the family and the caregiver to his brother, who is mentally ill, who has been diagnosed with mental retardation with 60% permanent disability, and the same has been authenticated by the disability certificate dated so and so, issued by medical authority Baksar Assam.
Yes, madam.
Madam, kindly see the citation. I have found it, madam.
No, in that case. it will
Here also, all the way was considered, and my lord, considering it was also considered the brother of the caregiver. But also brother is covered, my lord.
be the son of the petitioner.
That case is the son, my lord. But kindly peruse paragraph 5, my lord. By the subsequent office memorandum dated so and so issued by the government of India, keeping in mind the statutory element enactment of the rights of person with disability 2016, a fresh set of guidelines in supersession of the earlier guidelines were issued, which inter alia are as follows. A government employee who is a caregiver of the dependent, daughter, son, parents, spouse, brother, sister, and with specified disability. So that was considered, my lord. And in paragraph 19, my lord, kindly peruse. In view of the above, this court is of the opinion that even if the state of Assam has not framed any such memorandum, rules or regulation, it would be under legal obligation to follow the principles mentioned in the aforesaid memorandum in respect of their employees having similar problem. My lord, in this case, my lord, the impugned transfer order was set aside. So, at present, my prayer is, my lord, notice may be issued, my lord, and the transfer order may be stayed, my lord.
Miss Das, you are appearing for whom?
BTC, Your Lordship.
BTC.
BTC, on behalf of P. Nayak, Your Lordship. Your Lordship, let us take instruction, Your Lordship. Let the interim part may be considered on the next date, Your Lordship. I'll obtain instruction.
Appearing for the
My lord,
Mr. C.S. Adri. Government Advocate Assam appearing for the respondent numbers 1 and 2. Also heard Mr. Miss Ada. Corresponding counsel BTC for the respondent number.
Peters.
3. Since petitioner is serving block project assistant on contractual basis. A monthly fixed salary of rupees 15,000 per month under the state project director Ocean USHN in capital Ubian API YWL from Secretary Government of Assam in the Social Welfare Department and posted at Jala ICDS project under District Social Welfare Officer of Assam. by order number BWCDO within bracket BKS Ocean oblique 35 dash A oblique ESTP oblique 2021 oblique 173 oblique 613 dated 31/05/2023. The District Social Welfare Buxa transferred the petitioner from Dala ICDS project and posted him at Goresh ICDS project at Goresh, and in his place transferred on Vikas Das, block project assistant, Ocean region, from Goresh ICDS project, posting him at Dala. Petitioner stated that his brother is a mentally retarded person, and to that extent, the concerned medical authority of Buxa, Assam issued disability certificate as in favor of his brother on 14/06/2022, specifying him as a mentally retarded person. Petitioner submitted a representation before the District Social Welfare Moshalpur Buxa on 29/08/2023, requesting the said authority to not to give to not to give effect to the said transfer order dated 31/05/2023, issued by the said authority, transferring him from Dala ICDS project to Goresh ICDS project. Some immediate details about this said mentally retarded father, and considering a girl child, baby girl child born to him during the same. In disregard, the petitioner placed an office memorandum of the Ministry of Personnel, Public Grievances and Pension, Government of India, issued on 06/06/2014, as well as the office memorandum dated 08/10/2018, issued by the same authority, clarifying that while transferring the incumbents during routine exercise of transfer of rotational transfer, exemption should be considered for the caregiver with regard to specified disability, including mental illness. It is stated the petitioner is the caregiver to his brother Noyon Haloi, suffering from mental retardation. The petitioner has also placed reliance on a decision of this court in the case of Dr. Netramani Kakoti versus State of Assam and others, decided on 21/05/2019 in bracket WPC number 3091 of 2000. Caused by a coordinate bench of this court, wherein the court observed that the caregiver of a dependent brother should also be considered for such exemption who suffers from benchmark disability. In the same decision, the Honorable Court considered. Please take your seats. Section 2 in bracket small d that relates to caregiver under the provisions of the Rights of Persons with Disabilities Act 2016. Wherein it is specified, wherein it is stipulated that any person, including parents and other family members, who which or without payment provides care, support, or assistance to the person with disability. In the same decision dated 21/05/2019, passed in the case of Dr. Netramani Kakoti Supra, the court went ahead with the observation that during the process of judicial review, if the court comes to the conclusion that the authority had passed an order without taking into consideration the relevant materials or factors, that would be a ground for interference by the court. And accordingly, the court set aside the impugned transfer of said Dr. Netramani Kakoti was found to have a son suffering from autism spectrum disorder with mental retardation. Considering the above, during the deliberation of the matter, Mr. Boyso on instruction submitted that petitioner has not yet been released from the Dala ICTS project pursuant to the order of his transfer dated 31/05/2023 issued by the District Social Welfare Officer. In view of the above, this petition is disposed of at the motion step itself, directing the petitioner to submit his representation before the District Social Welfare Officer honor before zero 06/10/2023, along with a copy of this along with the copy of decision of this court in the case of Dr. Netramani Kakoti Thereafter, the district social officer after honor report 31/10/2023 shall dispose of the representation of the petitioner pertaining to the prayer of cancellation of this transfer from Dala ICDS to Godeshwar ICDS project by the order dated 31/05, intimating the petitioner about the outcome. Till then, the status quo as on today with regard to the petitioner as block project assistant within bracket portion provision portion for capital minority at Jala ICPS project shall be
Minor petitioner may be allowed to produce relevant documents if necessary.
along with all the relevant medical documents or part of it.
Always, man, deeply.
Deeply obliged.
Yes, Mr. Doctor.
This petition has been filed for non-payment of arrears salary, my lord, with effect from 11/9/2017 to 28/2/2021. My lord, pursuant to
Where is the order of reinstatement in your service?
it's
13.
my lord,
13.
13
Page.
page 13, annexure 2, my lord. Last paragraph.
Mr.
Next
Doctor,
page.
whether the final report was accepted?
Yes, my lord, next page 14, my lord. It is the
Want to
following
know from
affection.
you whether the FR was accepted or not.
Not,
Hmm?
not this.
In the police case, final report has been accepted by the concerned magistrate or not?
Yet, but my lord, they have treated my that period as on duty, my lord, and proposal we have submitted.
We want to know from you, Mr. Doctor, whether the concerned magistrate has accepted the final report with regard to the concerned police case
Yes,
in
my
which you
lord.
are involved.
That yet to receive. The director by the order that section 3 2022 treated that period as on duty, my lord.
During the period of your suspension, have you drawn your subsistence allowance or not?
No, my lord, it was suspended on 11/9/2017, my lord.
Hmm.
And 23, 20, it was reinstated on 23/7/2021, my lord. Yeah, he hasn't paid the substance allowance, my lord.
You have drawn,
Yes,
you have drawn the
yes,
subsistence allowance.
yes. In a criminal case, my lord, the CC cameras report came up, my lord, and it is established that they demanded and misbehaved with the principal, some student, my lord. They even locked the door of the principal room from outside, my lord.
But Mr. A.K. Datta, learned counsel appearing for the petition. And Mr. D. Upomenu, standing counsel, higher education. For
1 and 2, Lord.
respondent numbers 1 and 2. Also heard Mr. A. Saliha, standing counsel, finance. Respondent numbers 3 and 4. Petitioner is the principal of Ravindra Sudan Girls College, Karimka, a provincialized degree college of the state. Thereafter referred to as state college. Matter relates to the claim of arrear salary by the petitioner for the period from 11/09/2017 to 28/02/2021, during which he was under suspension. Since the petitioner was arrested in connection with Karimganj Police Station case number 831/2017 under section 352/354 in capital B IPC, read with section 67/67 within bracket capital A of the Information Technology Act 2000. The Director of Higher Education Assam, by an order dated 11/09/2017, suspended the petitioner from service under Rule 6 within bracket 1 of the Assam Employees within bracket Disciplinary Act 1964. Later, after investigation, inside Karimganj PS case number 831/2017, the investigating officer of the case submitted a final report. Earlier, petitioner approached this court in WPC number 4447/2019. It was disposed of on 14/12/2020. Pursuant to the order of the court dated 14/12/2020, passed in set application number 4447/2019, referred by the petitioner. In the disciplinary proceeding initiated against him, the concerned inquiry officer, the Deputy Director of Higher Education Assam, on 27/02/2018, submitted the report, observing that the petitioner may be reinstated in his original substantive post of principal of said college, subject to the outcome of the police case registered against state police case registered against him. Since the investigating officer in said Karimganj PS case number 831/2017, corresponding to GR number 2001/2017, submitted a final report. The Director of Higher Education Assam, by an order dated 23/03/2021, reinstated the petitioner in service in his original substantive post of principal of the said college. In compliance of the order dated 14/12/2020, passed in application number 4447/2024, passed on. By resolution number 2, the dated 08/07/2021, the governing body of the said college, Karimganj, treated the period of suspension of the petitioner from 11/09/2017 to 24/03/2021 as on duty. Considering the speaking order dated 23/03/2021 of the Director of Higher Education. Petitioner, after his reinstatement in service, pursuant to the said order of the Director, DH Assam, dated 23/03/2021, the petitioner joined his service as principal of the said college, Karimganj, on 25/03/2021. The Director of Higher Education Assam by an order dated 16/03/2022 approved the said resolution number 2 dated 08/07/2021 of the governing body of the state college, and treated the period of suspension of the petitioner from 11/09/2017 to 24/03/2021 as on duty. After resigning as a principal of the state college, Karimganj, he continued to remain as the drawing and disbursing officer towards payment of salary to the staff, to the teaching and non-teaching staff of the state college. Though an ADR proposal for an amount of rupees
26 lakh.
26,68,477 was submitted before the Director of Higher Education Assam by the petitioner with due breakup from 11/09/2017 to 28/02/2021. Deducting the subsistence allowance drawn by him during the period of his state suspension from Satan. But along with non-royal certificate. But the responding authorities in the Directorate of Secondary Education Assam has not yet processed the said proposal of payment of arrears salary petition in spite of submitting reminders being agreed. The petitioner has to fund this. After hearing the land council for the parties, this petition is disposed of at the board of Secretary, directing the petitioner to submit certified copy of this order along with the proposal of his arrears salary for the period from 11/09/2017 to 28/02/2021. Period which he remained under suspension, along with non-royal certificate and other relevant documents before the Director of Secondary Education Assam. Obtaining necessary on or before 06/10/2023, obtaining necessary acknowledgement from the said authority. Thereafter, the Director of Secondary Education, Director of Higher Education Assam shall duly process the said proposal arrears salary of the petitioner for the period from 11/09/2017 to 28/02/2023. And shall pay the same with due approval of the Finance Department of the same as per the entitlement of the petitioner in accordance with law. If there is no other any impediment, releasing the same, the entire process shall be completed on or before 31/01/2024. The respondent, if the petitioner is found entitled for the same.
Highly obliged.
Yes, Mr. Mr. Mao?
May prevail. So this is basically suspension matter. My lord. The petitioner is aggrieved by the inaction of the respondent authorities in not taking a decision on his joining report. My lord. The facts of the case are like this, my lord. In the year 2005, my lord, 2015, when the petitioner was working as an inspector in the GRPS police station at Cotton Bazar railway station, my lord, he was accused of having demanded some money from a person. Based on that allegation, my lord, the DP and criminal proceeding was drawn against him. He was also placed under suspension. Subsequently, the suspension order was revoked. In the departmental proceeding, my lord, resulted in, my lord, the infliction of the penalty of, my lord, the penalty of reduction, withholding of one increment with cumulative effect, my lord, and that penalty has already attained its finality. In the criminal trial, my lord, he was convicted, my lord, and he was taken into custody again. Being aggrieved, he filed an appeal before this honorable court, and this honorable court has suspended the operation of the sentence and released him on bail, my lord. That order lordship will find that page, it starts at page 64, the operative portion is at page 66, my lord. Last paragraph.
Yes, then
Thereafter, my lord, he immediately preferred a representation, my lord, allowing, making a prayer before the authorities to allow him to join in service. That representation lordship will find at page 67. And thereafter, thereafter, my lord, the office of the superintendent of police, my lord, had written to the office of the director general of police, asking him to instruct him on the issue. That that letter, my lord, will find at page 68. The superintendent of police, Kokrajhar, writes to the director general of police to instruct him as to what action is required to be taken on the joining report. The relevant paragraph would be the last paragraph, my lord, page 69. In this regard, the undersigned may kindly be instructed as to whether the joining report of the officer can be accepted, and if so, the undersigned may also kindly be instructed regarding drawal of his pay and allowance as admissible with effect from 5/1/2021, which has been held up until further order. It is pertinent to mention here that the pay and allowance of the officer concerned was made up to 31/12/2021. It should have been 20. My lord, it's a typographical error.
Mr. Sachia,
My lord, I have obtained instruction, my lord.
My
no
lord,
instruction is required. No,
it's covered, my lord,
why covered?
under exactly similar facts and circumstances. This honorable court has passed.
No, my lord, his joining report is 2021, March. That he has come before your lordship today, my lord. There may be
He's
some
knocking
valid
the
reason.
doors.
Paragraph 6 onwards should be relevant. In terms of this order, the petitioner is required to be considered as to be under deemed suspension.
That's under 6(2),
6(2), my lord.
but in your case, you have been convicted by
Convicted,
the
my
trial
lord.
court.
In that case also, that person was exactly similar facts and circumstances.
Okay.
6(2) has been invoked. Paragraph 6 onwards. The reason why 6(2) has been invoked, it's given there, my lord.
Mm.
Do you have a extra copy of this?
This, I
Read para 7.
Para 7. From such point of view, we cannot find any infirmity on the part of the respondents in not allowing the petitioner to resume his service. In the circumstance, the remedy available for the petitioner would be to invoke the proviso to Rule 6(2) of the rules of 1964. In the meantime, as the petitioner has been released from custody, the remedy available would be to invoke proviso to Rule 6(2) of the rules of 1964 and require the appointing authority to take a decision as to whether the detention of the petitioner is on account of any charge not connected with his position as a government servant, or continuance in office is likely to embarrass the government or the government servant, or the case does not involve moral turpitude, and accordingly to take a decision as to whether the order of deemed suspensions requires to be
Now you
executed.
come under which ground?
My lord,
Why you have been convicted?
my lord, section 15 of the Prevention of Corruption Act.
While discharging your duty, you are found to be involved in that.
Yes,
Then why, how did, if you have read para 7, will you come under any of the grounds specified therein?
my lord, I'm not saying before your lordship that I should be reinstated in service, my lord.
That's what the decision have to be taken by the
Taken.
authorities concerned.
And by
Mr.
operation of 6(2), I'm required to be
Read,
considered,
only that considered,
and
those 3 grounds specified in para 7.
they will take a decision, my lord.
Take a decision.
And
Yes,
during,
Madam.
and
Then
during,
you inform the superintendent of police Kokrajhar, because he's been filing his application for his dismissal.
My lord, I think my lord, IGP will take decision, my lord.
Definitely. The head of the authority will
Yes, IGP administration.
dispose of it.
Let's say otherwise dispose of, otherwise.
Yes.
and my lord, for this period, he is required to be considered as to be under deemed suspension and my subsistence
His
allowance.
involvement in the criminal case is not during his, my lord, official
What
duty.
Mr. B. Sharma, learned counsel appearing for the petitioner, and Mr. P. Sutia, Chittagong and Advocate Assam, for the respondent numbers,
All the respondents.
for all the official respondent numbers, 1 to 4. Petitioner, the Deputy Superintendent of Police, Border, Kokrajhar, Assam. While he was discharging his duty as an inspector from officer in charge of CRPS police station, the Kolkam Bazar railway station, Guwahati, he was found demanding money on one of the person therein, basis of which ACP PS case number 06 of the 2015 was registered. He was arrested
Yes, my lord.
Arrested.
and detained in custody.
Page 24 is the suspension order, my lord, and 24 is the subsequent revocation
By
of
the
the.
order dated 08/07/2015, issued by the Director General of Police. By an order dated 10/01/2017, the petitioner was reinstated in service pending departmental process. During in the discipline proceeding initiated against the petitioner, the petitioner was found guilty, and the Director General of Police, concerned disciplinary authority, by order dated 18/01/2019, imposed the punishment of stoppage of 1 increment with cumulative effect upon the petitioner, treating the period of his suspension for the period from 08/07/2015 to 10/1/2017 as on leave. With the further observation that the period of judicial custody or his involvement in said SCP-PS case number 06 of the 2015 under section 1 in bracket capital E public 387 the IPC rated section 7 13 in bracket capital Roman 1 bracket in bracket small d public 13 in bracket numerical 2 of the Prevention of Corruption Act 1988 as dies non on the principle of no conflict. the special case number 02 of 2018 arising out of said SCPPS case number 6 of 2015. The learned special judge Assam by judgment and order dated 051/2021 convicted the petition
Page 60, paragraph 86 and 87.
with rigorous imprisonment for a period of 3 years with fine of rupees 7,000 in default of payment of fine, rigorous imprisonment for 1 month under section 7 of the Prevention of Corruption Act 1998. With further rigorous imprisonment for a period of 4 years and fine of rupees 10,000 in default payment of fine, rigorous imprisonment for 2 months under section 13 of the 2 of the Prevention of Corruption Act 1988, where the sentence is against the said order. Judgment in order it is filed by learned special judge Assam, special case number 02 of 2018. Petitioner preferred criminal appeal number 24 of 2021. Along with an interlocutory application being I.A. criminal number 54 of 2021. Seeking the court by order dated 18/03/2021 admitted the said criminal appeal of the petitioner criminal appeal number 24 of the and granted bail to him. It said such and such. As the petitioner was released on bail, the said criminal appeal number arising out of the he on 23/03/2021 submitted the joining report before the Superintendent of Police order. It is stated that though the Superintendent of Police order Kokrajar Assam sought necessary direction regarding the reinstatement of the petitioner, that's reinstatement of the reasoning of the petitioner in service from the Director General of Police Assam. But as the said authority till yet did not pass any order, the Superintendent of Police order Kokrajar could not accept the reasoning of the service as Deputy Superintendent of Police order.
Thereafter, there was another report made. page 72 and 73.
The Superintendent of Police Code of
Communication.
also issued reminder to the Deputy Inspector General of Police, Assam, that paper as to whether the petitioner should be allowed to join the service as the police bail granted to him by the High Court. In support of his contention, Mr. Sharma and counsel for the petition relied on a decision passed by a coordinated bench of this court on 10/11/2021 in WPC number 5858/2021. Versus where the state petitioner led the petition, inspector of the court was arrested on the prevention part of the crime. And bail was granted by the High Court of the district
Convicted man.
of the was convicted decidedly against referred by him like it's a in a state order dated 10/11/2021, passed in WPC number 5858. The court considered the fact that directed the authorities concerned the concerned appointing authority to take a decision regarding his resigning in service after release on bail, though he was convicted by the trial court. As to whether the bracket one, the detention of the petitioner was on account of any charge not connected with his position as a government employee or continuance in office by him not likely to embrace the government or free. The said government employee embrace or the or the charge does not involve moral turpitude. Considering the same, after hearing the response, the petitioner is directed the public before the friend of police for present. Is returning in getting bail by the court of substance self-protective. Assam.
That's for number 2.
And the state authority, the Director General of Police, Assam, thereafter shall consider the representation of the petitioner within a period of 45 as to whether the rejoining plus restatement of the petitioner after and shall pass necessary authority. The petitioner can be allowed rejoin and deputy superintendent implementing him. The entire 15
I'm satisfied with the order.
He will
Only one,
furnish the certified copy.
only one thing, my lord. In terms of the order which I placed before your lordship, my lord, if they take a decision which goes against me, my lord, in that event, my lord, the period from which I was taken into detention, my lord, till today, my lord, that is required to be treated as deemed suspension. My lord. That benefit, my lord, I'm paying for. This is in terms of this order only.
No, they will take the decision, my lord.
in your representation
Then they will take.
to submit that, we will pass an order to even to consider the same in accordance.
Obliged, my lord.
Here in this matter is to receiving the financial service benefits of the petitioner's husband, Manas, who was missing since 31/12/1998, Manas. As annexed all the police reports as well as the certificates, Manas. It starts from page 13 to 22, Manas.
Where is the police report?
Page 13, Manas.
1-3.
2 reports, yes, Manas, I have annexed.
Final
The
report.
certificate is also there, and the certificates and police report is annexure E, page 19, my lord. And there are a number of certificates also issued by the in-charge Patsala Police Outpost.
Yes, tell us.
My lord, the petitioner has never approached the FCI, my lord. She has come directly to the court, my lord, and stating in the paragraph 7 that inaction of the respondent, my lord. She has never approached the FCI, my lord. That
My
her
lord,
husband is missing and so she required the service benefit. Let her approach the FCI, my lord. By
Yes.
filing a representation, never file
Yes,
any
my
representation.
lord.
How the FCI will know?
A direction may be given to the petitioner to submit a representation which may be considered by them, my lord.
Then why you made that statement if you have not approached the FCI authority?
My lord, she has approached personally, my lord.
Where?
I have made statement, my lord, at para 7.
When did you last approach?
Like, I have not found any such statement.
My lord, para 6 at page
Just
7,
tell
my
us
lord.
one thing, if the person is,
Unfortunately, petitioner has been running from pillar to post praying for the aforesaid benefits,
if the
but
person
the
is
respondent
missing,
authorities have turned a deaf ear and have done nothing.
if the person is missing since 1st of January 1999,
Yes, my lord.
why you have preferred this state petition in the month of September 2023?
My lord, because she has not received any benefits, my lord, service benefits of her husband, my lord. I have annexed the, my lord, my lord, a document showing that his some husband had been serving under this department, my lord, which
Now,
is
if a
annexure
person
A at,
is
A
found-
at page 12.
If a person is found missing or untraceable for more than a period of 7 years after lodging the complaint before the police station, what is the procedure?
He should be declared dead by the court, my lord,
By whom?
by the possible court.
Without
Dear my
that,
lord, she, in fact, she is an
whether-
illiterate
without
lady, my
that,
lord.
will you get any benefit? Tell us. Whether
She is an
without that, will you
illiterate
get any
lady. She does
benefit?
not know any procedure
That's true. It's the duty of the lawyer to advise the concerned client.
and she has not
Now-
approached any lawyer also.
Without that, if you are aware of the fact that what is the procedure to be followed, now simply by directing the petitioner to file a representation before the FCI and to directing FCI to consider, will that do?
My lord, that is.
She will have to obtain the next of kin
That is there,
certificate.
my lord.
Well, next of kin
First of all,
certificate, she
there has
will
to
need
be
a
a
declaration
declaration.
that her husband is died.
That she.
There has to be, where is the declaration?
Declaration is not there.
Then why you have filed, why you have asked the petitioner to file this petition? You should have advised her to first obtain that. Either we will dismiss or you withdraw.
My lord, I know.
Or Mr. or MS F. Chaudhary and also appearing for the petitioner. And Mr. P.K. Singh, standing counsel FCI. For the respondent. Respondent of the case. Husband of the petitioner, a grade 4 employee of the FCI. District officer Guwahati. The FCI. Guwahati,
He who?
District officer Guwahati. While during his last posting at FCI officer, it is alleged that the petitioner, husband of the petitioner was found, husband of the petitioner, Ramani Sharma, found missing. And in that period, a police complaint was lodged before the Pachala outpost district operator on 01/01/1999. Was registered as Pachala outpost general diary entry number 12 dated 01/01. By this application, the petitioner is seeking relief for the service benefit of her husband who is missing, allegedly missing from 1/1/1999 from the respondents here. On being inquired, it is admitted by the petitioner that her husband has not been declared. At this stage, on instruction of the petitioner, Ms. S. Bishop, prays for referral of this great petition to the liberty to file appraise as and when this cause of action arises. They are allowed petitions and request liberty as stated. Yes, Mr. Das.
My lord, your lordship will kindly see section 16(5) of the RTI Act. Your lordship, see.
We have. What is the prayer you made?
The benefit of the 16(5), my lord.
No, earlier round of litigation, court had directed that a reasoned order be passed. That order has been passed in Annexure 21. That my learned senior is challenging, your lordship.
You come here.
Not learned senior, it is challenged by the petitioner. He is not challenging.
If you want to submit first, then let me come and submit, my lord.
Just 16(5).
Yes. No, you should understand. Somebody is while they are arguing, suddenly you come and say something.
Sorry.
(16)(5)(b), my lord. He's a state, my lord, commissioner, information commissioner. He was appointed in the year 2015. Prior to that, he was working as Indian Audit and Account Service since 1983. After his superannuation in the year 2014, my lord, he was appointed as State Information Commissioner. That your lordship will file page 36, page 36.
Yes.
2015. Now he retired. Pleased to appoint Sri Bosumatari as the State Information Commissioner in the Assam State Information Commissioner constituted by section so and so with effect from his entering the office. He shall have taken oath of all these things were there, but he was appointed and he was there for 5 years and he retired from service in the year, I think, 2019. Then thereafter, my lord, he was not giving the benefit of 16(5) section. Therefore, I am saying, my lord, your lordship will kindly see section 16(5). B. Married man.
16(5), yes.
Yes. The State Chief Information Commissioner shall hold office for a term of 5 years from the date on which he enters upon his office and shall not be eligible for reappointment. Now 16(5), your lordship will kindly see 5, subsection 5. The salaries and allowances
16(5).
paid, yes, subsection 5. The salaries and allowances
16(5)(b).
paid, my lord,
16(5) is not available here.
16,
1/6. 5 is there. Start with the salary.
yes, then 5 salaries, yes, then B is there.
Is the 2020
Mother-
Act. There is no
No,
B.
that is amendment in the year 2019.
No, no,
Pre-amendment
this
is
the 2020
this.
Act.
Hello?
This is 2020 Act.
Yes,
Pre-amendment.
that is because of the amendment. In that case, your lordship will find it in the
Old
footnote.
Act.
Hold on.
Just a minute. Just
Footnote, your lordship will get.
yes, it is.
Yes.
It is there.
Yes. So
The
it
State
is,
Information
yeah,
Commissioner
the
shall
State
be-
Information Commissioner shall be the same as that of the Chief Secretary to the State of Assam.
That's right.
Then the salaries and allowances payable to and other terms and conditions of the services are like the chief secretary of the state. This is the case, my lord. We came before this honorable court earlier, and this honorable court, has been dated, my lord, page 59.
Served as
Chief State Information
Commissioner
Commissioner.
for the
So,
period from when? From 31st of July 2015
yes, ma'am.
to
219, my lord. That period I'll give it, my lord. Take it, sir. Take it. 5/4/20, madam. That your lordship will get the earlier, in earlier order, madam. The earlier order, my lord, that page 6 starts from page 61. Relevant, I will say, my lord, is paragraph 7, page 63.
just a minute. Just a
I finish.
Yes, which page?
Yeah, page 63, my lord.
Yes, para.
Para 7. May I read this?
Yes,
Small paragraph. In view of the legal fiction under section 16(5) of the RTI Act 2005, wherein it is a statutory provision that the salaries and allowances payable and the other terms and conditions of service of the State Information Commissioner shall be as that of the chief secretaries of the state. The stand of the respondents that as the two writ petitioners, earlier two writ petitioners were there, here one, have neither served as the chief secretaries nor in the rank equivalent to chief secretaries, they would be disentitled to the benefits of salaries and allowances, and other benefits of that of the chief secretaries of the state would be unacceptable in law, inasmuch as by virtue of legal fiction under section 16(5), they would be so entitled as statutorily provided. Accordingly, the respondents are directed to pass a reason order on the claim of the two writ petitioners for their services benefit, including retirement benefit and pension, if applicable, in the same terms and conditions as that of the chief secretary to the government of Assam. Now they have passed an order relying on a division bench order. That division bench have considered whether a state chief commissioner will be entitled to the benefit of the chief commissioner. So that your lordship will find the order which they passed is at page 65. Actually, they have quoted the division bench order passed in Arunachal Pradesh in respect of where they were seeking the violation. They were showing there is a violation of Article 14 for not considering the pay of the State Information Commissioner to that of the State Chief Information Commissioner. So page 65 is the order. They have never discussed it as section 16(5).
No, please come to 67.
Yes, 67, yes. 16(2) RTI Act 2005.
No, thereafter down below, quote, proviso, then 16(5) is there in between.
Yes, they have quoted this, but they have not discussed. This is not they have quoted this. Then last paragraph they said, while letter number so and so 2023, then written by the additional secretary to the government of Assam Administrative Reforms, Training and Pension Grievances Department, it has been informed that the central government employees are getting retirement benefit as per the Central Civil Service rules to 1972 prior to 21, but they have never said why the salaries will not be a par with the salaries and allowances will not be par with the section 16(5)(b). Never discuss. They page 68, your lordship will kindly see paragraph 4. The aforesaid lead petitioner Sri Bosumutari has demitted, paragraph 4, madam, has demitted his office as State Information Commissioner on 31/12/19. At that relevant point of time, the Chief Secretaries to the Government of Assam were paid pension under the 72 rules. A reading of the provisions of the Central Civil Service rules, more particularly Rule 49, shows that in order to be entitled for pension, there is also a corresponding requirement of a minimum qualifying service for pension concerned to have served, and minimum qualifying service would be 10 years. But as per the provisions of the RTI Act relating to appointment of a State Information Commissioner, it is found that the term of appointment is 5 years, and therefore it has to be understood that the minimum qualifying period of 10 years of service would not be satisfied in the case of a State Information Commission. This is based on a division bench judgment passed by in Arunachal Pradesh, which states, I am going to provide that copy. Now, they have not discussed the 16.5. 16.5B have not been discussed anywhere.
Decided on, it's reported.
It is reported, I think so, my lord. I got a,
GLT 474.
yes,
But let us see what is the finding therein.
yes, it's paragraph 24, your lordship will kindly see. And I'm giving another judgment that has been written, I think, more better, my lord. In view of the above, we have to conclude that the relief sought for in this writ petition and declaration that the State Information Commissioners are also entitled to a pensionary benefit as applicable to the State Chief Information Commissioner in the state of Arunachal Pradesh cannot be accepted. So this was the contention there. Now your lordship will kindly see this Kerala judgment. I think 2023 SCC online, Kerala 2449. This Arunachal Pradesh judgment is totally different. They were saying that we should be getting the pay and allowances of the Chief Information Commissioner. And by the direction of this court directed under 16.5, you consider you cannot go away from that. As a lordship government, Kerala judgment. This is a well-written judgment, I must say that.
Let's take it.
Okay.
Yes, Mr. Hazarika.
I'll just show one judgment, Miller. The 2023, that Kerala judgment. This is a well-written judgment, Miller. That's why I wanted to show. 2023 SCC online Kerala. SCC online Kerala 2449. There also, my lord, order of disposal was there for considering medical benefit as per the central, because he was getting all other benefits. Has your lordship got it?
Now, which citation?
2023 SCC online, Kerala 2449. 23.
Kerala?
Kerala 2449, madam. 23 3 KLT 187.
2449.
Yes. Online, SCC online. S. Somanathan Pillai.
S. Somanathan, just give us the name.
S. Somanathan Pillai. In my tab, my lord, Your
It is
Lordship.
coming.
Coming.
Difficulty is our net system is very old. Now that's why we are not getting many things. And it needs a huge cost for changing it. Yes, which paragraph you want?
My lord, your first paragraph, Your Lordship, will kindly say. The grievance of the petitioners is that, my lord, second paragraph. May I just read this paragraph?
You want to take it?
I can give it in my pad if it is not available.
You will have.
The grievance of paragraph 2, Your Lordship, can you see? The grievance of the petitioner is that while section 16(5) of the RTI Act provides that the salaries and allowances payable to and other terms and conditions of service of the State Information Commissioner.
Mr. Das, we want to know whether it was disposed of on 23rd of March 2016.
23 April, my lord, decided on April 4,
Just a minute.
23. My lord, Your Lordship, can you see this pad? I'm giving it.
No, it's okay. We'll have it.
And soon, I think all the lawyers will have better method. It did.
We'll have the case number.
My lord, from that.
Decided on 11th of April 2023.
Yes, ma'am.
That's correct. Got it.
Paragraph 2, Your Lordship will say.
Yes, yes.
I'll just read this. The grievance of the petitioner is that while section 16(5) of the RTI Act provides that the salaries and allowances payable to and other terms and conditions of service of the State Information Commissioner shall be the same as that of the Chief Secretary to the state government, the petitioners have been denied the benefit of All India Services Scheme 2020 applicable to the Chief Secretaries on the ground that the Chief Secretary becomes eligible for All India Services Scheme 2020 only by reason of being a member of the All India Service. The argument of the respondents is that since the commissioners under the RTI Act are not members of the All India Services, the All India Services 2020 will not ipso facto apply to the petitioners. All very nice arguments have been done. Even the Prime Minister's view expressed in Lok Sabha has been also discussed. Para 2021. Para 2021. And has your lordship got it?
Yes, yes.
Para 2021, Prime Minister, what Prime Minister? Para 20 says, my lord, while considering the issue agitated by the petitioners, it is necessary to examine and understand the relevance and importance of Section 16 in the RTI Act. The Minister of State in the Ministry of Personnel and Public Grievance and Pension and Parliamentary Affairs, while moving the motions for considerations of the RTI bill, said, we wanted this to be known emphatically that the citizens of India was not only free to ask for information from government, but also had a right to get it. The scope of this bill extends to all the authorities and bodies under the constitutions constitutions or any law, and inter alia includes all authorities under the central government, state governments and local bodies. Now, para 20 or 21, your lordship can say, the Prime Minister intervened in the Lok Sabha debate on the Right to Information Bill and stated, Mr. Speaker, sir, efficient and effective institutions are the key to rapid economic and social development. Institutions which can translate promises into policies and actionable programs with the least possible cost and with the maximum possible efficiency, institutions which can deliver on the promises made and convert, as the Honorable Prime Minister pointed out a few days ago while presenting the budget outlays into outcomes. For institutions to be efficient and effective, they must function in a transparent, responsible and accountable manner. So thus, my lord, the paragraph 22 says, the law is applicable to all authorities and bodies under the constitutions or any other law, and all authorities under the central government and state government. The RTI Act is therefore a powerful weapon in the hands of ordinary citizens.
Okay.
Now, para 24, all the benefits.
I've just read.
Very nice, elaborate judgments, and they cannot escape from the benefit of 16(5)(b), my lord, on the basis of the Arunachal judgment, where they have not discussed, my lord, the provision of 16(5)(b) in any manner.
Mr. B.D. Das.
Well, I would only pray, my lord, your lordship, since it is a second round, at the admission stage, if it can be considered.
Let us.
He is retired in the year 2019. man.
R. Deka, Land Government, Land Council for the petitioner. Also heard Mr. C.S. Adhikal and Government Advocate Assam for the respondent, for all the respondents.
No, your lordship, one and three. Assam Information Commission
1, 2,
possibly.
3. Oh, 1 and 3.
1 and 3.
And MS Standing Council AG Assam for the respondent number 4 and Mr. Exeliha Standing Council Finance for the respondent number 5. Petitioner. The additional secretary government of Assam, the administrative reforms and training department by an order by notification dated 31/07/2015 appointed the petitioner as the State Information Commissioner in the Assam State Information Commission under section 15 within bracket 3, the Right to Information Act 2005, prior to the last amendment. Prior to its last. The petitioner served in the seat capacity up to 5th of April 2020. Earlier, the petitioner approached this court in WPC number 4497/2021. As well as WPC number 4569/2021. Only 4569. Seeking the benefit of his salary and other financial benefits in terms of the provision of section 16 within bracket 5 of the Right to Information Act 2005. Prior to the amendment of the said 2005 Act in the year 2019. The court, after hearing the matter at length, by order dated 16/11/2022, disposed of said writ petition of the petitioner application number 4569 of 2021. directing the respondents in the Commissioner Secretary Government of Assam in the Administrative Reforms Department, Administrative Reforms and Training, Pension, Public Grievance Department, to pass a reason order with regard to the claim of the petitioner for his service benefits, including retirement benefit and pension under Section 16 within 5 of the Right to Information Act 2005, as issued prior to 2019 amendment, if applicable, in the same terms and conditions as that of the Chief Secretary Government of Assam. Pursuant to the same, the Commissioner Secretary Government of Assam in the Administrative Reforms, Training, Pension and Public Grievances Department, by the impugn order dated 12/04/2023, rejected such claim of the petitioner regarding the claim of his benefit equivalent to the retirement benefits of the Chief Secretary of the State of Assam. Discussing a division bench judgment of the Arunachal bench of this court in the case of Eken Riba, EKEN, Riba and others versus State of Arunachal Pradesh and others, decided on 30/11/2021. Reported in 2022, (1 DL 4. Mr. Das Lanet, General Counsel, appearing for the petitioner, on the other hand, placed a copy of the order dated 11/04/2023 of the Kerala High Court in the case of S. Somanathan Pillai versus State of Kerala, similarly placed as that of the petitioner herein, where the court considered the prayer of the said petitioner. Mr. Das Lanet, General Counsel, appearing for the petitioner from the impugn order dated 12/04/2023, also placed before the court that the authority concerned, while considering the case of the petitioner in terms of the direction dated 16/11/2022, passed earlier by the court in WPC number 4569/2021, did not even consider the provisions of Section 16 within bracket 5 of the Right to Information Act 2005, as it was prior to the amendment in the year 2019.
And as directed by the division bench, directed by the court.
No, that's what order as directed by the. On mere perusal of the said impugn order dated 12/04/2023, noted above, it can be seen that the authority concerned rejected the case of the petitioner on the basis of the decision of the division bench report in the case of said Eken Riba, wherein the issue involved was related to the claim by the said petitioner and 3 others State Information Commissioners of the state of Arunachal Pradesh claiming the benefit of retirement benefit as that of the State Safe Information Commission of the state of Arunachal. But did not discuss the provisions of section 16 within bracket 5, the said of the RTI Act 2005 as it still prior to 2019 amendment. Issue notice returnable by 8 weeks. As such and such formal notice, petitioner the impugn order number AR.51/2021/174 dated 12/04/2023 issued by the Commissioner Secretary Government of Assam Administrative Reforms, Training, Pension and Public Grievances Department shall be subject to the outcome.
Not sure that Assam Information Commission, that will be by register.
The petitioner shall take steps.
Instead of 8 weeks, may I pray 4 weeks only. Second round, man.
Nobody will work. Only the
Let it be 6 weeks, man. Let it be 6 weeks, because he has retired now, he's more than 70 years.
one.
Let it be 6 weeks. Apology.
May I please, Your Lordship? I'm
I'm
very
deputy.
sorry to interrupt, Your Lordship. I have an urgency. I need to reach hospital. Item number 20, Lordship.
You want to be adjourned?
Yes, Lordship. It may be fixed next week, any date, Lordship.
We'll see if not next week, we'll be around.
Lordship, much obliged.
We'll keep it on.
Mass email.
May I appeal, Lordship? In this case, Lordship, what happened, Mr. M.M. Kotak, he is standing counsel, animal and husbandry. So he is not keeping well. So he told us to take a adjournment because this cannot be come. So he let the matter come on Monday.
Tuesday, Lordship. I have some business Monday.
Tuesday, we have no problem.
Obviously. Deep obliged, Lordship.
I mean, on your writ petitioner, my lord. In this case, mother-in-law filed a petition for implementation. Mother-in-law filed petition for aired for restaurant number 5. I think it is not necessary. So, copy is not supplied, my lord.
Yes, Lordship. I want to take your Lordship to the.
We were supposed to file an additional affidavit that we have done it today. There was some mistake regarding the total computation of the amount that Lordship has given us permission to file. We have filed the affidavit. Leaving apart that issue, the other issue was regarding that presumption of death, because petitioner is the wife of the person, husband who has died. Died means the presumption has to be drawn. So the issue was as to whether this honorable court will draw the presumption or a declaration from a civil court will be required.
My lord, may I submit before Lordship that already.
Otherwise, we have no dispute regarding the amount to be paid, but then that legal embargo is there.
that clarification is required by the company for releasing of the money.
My lord. My lord. My lord. No, my lord. I have got court judgment of this honorable court, my lord. So Lordship will find that no necessity. Court had drawn the presumption. This honorable court. Court judgment is 3 by Honorable Justice Gogoi and 1 by Justice A.S. Soikia, 1 by my lord B.P. Kotaki. So my lord, that copy is my copy, my lord. Your lordship copy is defined, my lord. This is your lordship. All the pension matter, my lord. Court had deemed they had drawn the presumption, my lord. First, I have quoted the provisions, my lord, 107 and 108 both. Because 108 is the provision of 107, my lord. I have got the books, my lord, also. My lord. First, head notice from paragraph 6, ma'am. my lord.
Yes, Your Lordship. Lordship. Yes. So only one thing, the judgment that we had produced on the last occasion, LIC versus Anuradha, it's a Supreme Court judgment. It does not particularly refer to the particular court where we have to go, but in paragraph 15, it says if a dispute of this nature comes up, then it has to be decided by drawing of evidence. So based on that, we were making a submission that if it is an issue of evidence, then probably the civil courts will be the competent court. But I leave it to your lordship. I'm not on that. My only anxiety and apprehension is that there has to be an order of presumption of debt so that the company can thereafter make the payments in a very safe manner. Because tomorrow if the person comes up and says, why did you give the money to someone else? Then we should not be in a difficult position. That is the only concern that the company otherwise has. The client, I mean.
They have not
respondents.
denied that I am not the legal heir. They have not denied in the counter. And there is another recent judgment, my lord, that is copied there in the file, my lord, by Justice Devashish Barua. Recent judgment, 2022, my lord.
Yes, Your Honor. Of that Anuradha judgment? Yes, Your Honor. Yes, court is there, I think. An occasion for raising. Yes. An occasion for raising the presumption would arise only when the question is raised in a court, tribunal, or before an authority who is called upon to decide as to whether the person is alive or dead. So long the dispute is not raised before any forum and in any legal proceeding, the occasion for raising the presumption does not arise. Yes. But ultimately, yes. Yes. Yes.
That's absolutely correct, madam. If he raised objection, then he has to prove it. That. Madam. Madam, already, madam, this court has already drawn presumption. Madam, may I play? My lord, I have got, my lord.
We have served. We have served. Yes.
I have got. My lord, yes, may not be disposed of, my lord, because my lord, I have other claim, my lord, because this amount was calculated up to 2006, my lord. 2006 to 2023, nothing was paid to the petitioner, my lord. The facts of the case is this, my lord. This issue may be, my lord, your lordship will find in the last order, my lord.
He was absent and thereafter
No,
he was
I'm
not to be seen. So
not-
therefore, the calculation and the computation has been made till the last date of his
My lord,
service in the company.
I want to take your lordship to the order
This
dated
was otherwise
19/6
accepted by him.
19/6/23, my lord. My lord. My lord. My lord, regarding interest, my lord, there is already this court has observed that the matter will be heard later, my lord. My lord. I am not on that, my lord, in this, but my lord. That is different matter, my lord. But here, my lord, the amount was, this amount was due on 2006, my lord. For this 17 years, I am entitled to interest as per the provision of the EPF Act also, my lord. Gratuity Act also, my lord. I am entitled to interest, my lord. That's why I want to take to your lordship to the order dated 19/6/23, my lord. My lord, these facts, some facts are different, my lord, in this case, my lord. Because, my lord, that's why, my lord, that matter was slightly different. This was decided in 2004, my lord. In my case, my lord, the petitioner is missing. Petitioner worked up to March 26, 2006, my lord. Thereafter, he remained absent, my lord. When he joined to duty in 2013, he was not allowed to join. Since 2015, he was missing. So this for 17 years, I am entitled to interest also, my lord. EPF amount, my lord, at least I am entitled to 9-10%, my lord, as per the law, my lord.
The wife is having a claim only after the presumption of this 7 years has elapsed.
No,
And that
that
has
is not
elapsed in
right.
2022. 15 was the FIR was
I am
filed.
not claiming from him interest, my lord. I am claiming from the department, my lord, from the EPF, my lord.
Then that will be a different cause of action.
No, the different cause of action, same cause of action, because EPF, you have paid the EPF due up to 2006, 2006 to
And let him
2023
file
now.
a case before the EPF authority for the interest.
But I have no consumer number. How I can apply for that?
He doesn't even know what is the amount that is due for him. He doesn't accept our amount.
I
As
am
if we had
accepting the
got some
amount. I am
grudge
not
against him.
objecting to that, my lord. Whatever I am entitled to extra interest, my lord. And some pension also, my lord. That is up to the court who will, that will decide, my
You
lord.
are getting pension. Pension amount is there.
18 of it is that?
That is the calculation.
মই আপত্তি কৰা নাই এইটো মই কি আপত্তি আছে মই যদি ইন্টাৰেষ্ট পাওঁ ইফালে কোৱা যে মোৰ আপত্তি নাই ইফালে আপত্তি নাই my lord I have filed I have prayer is that pensionary benefit be paid, but as part this I have, as the petitioner is no more, my lord, the wife has claimed the amount. How a wife came to know that how much amount is due she is entitled to, my lord? Today, a few days earlier, I came to know that I am entitled to this amount on 2006, my lord. Since 17 years has elapsed, my lord, I am entitled to interest for this 17 years from the EPF, my lord, organization also, my lord. I am entitled to interest on gratuity also, my lord. That was mentioned in the order. My lord. My lord. My lord. My lord, that will be considered at the time of hearing, my
Because
lord.
her
Your lord-
right have fructified only in 2022.
My lord,
After the 7 years is
may I
elapsed.
submit that, my lord? Your lordship may please to see the last order. What order this honorable court has held, my lord? Order dated, my lord, 19/6/23, my lord. The learned counsel for the petition submit that the petitioner is also entitled to interest. Such claim of interest requires some determination. Accordingly, this matter after vacation on so and so for a that time I am submitting that. This amount be paid and matter be heard after puja vacation, my lord. My lord. So I may be claiming interest also, my lord. My lord, how? I will produce the copy, my lord. Judgment is there, my lord. Because EPF is providing the interest to pay. Since last for this 17 years, they cannot withhold the amount, my lord. I am entitled to interest on that amount. Only the at present the matter relating to the amount whichever they have determined, my lord.
The EPF is not a party here in this proceeding.
this in earlier case, my lord, there were only 7 years or was concerned. My lord, here 17 years is concerned, my lord.
All India limit. Obliged, Your Lordship.
I'm sorry to mention, yes, madam. I had one matter, item number 13. I was outside, madam, but your lordship has passed an order for 1 week. I want date, only date, madam. Next week, your lordship passed. No, I have already served. Sorry? Hey, hey. Of course, I do not know M. Hussain, of course, Advocate M. Hussain. Oh, I have no knowledge. My lord, so let the matter be listed next week, my lord. Any date. Yes, my lord. Sixth of my lord, October. Oh, is it to 29th, my lord. Kindly be fixed on 29th. Oh. কি কৰে হে নিদিলে সুধিব লগা হৈছে তাক। I file an impleading petition. Ashok Kumar Das. Highly obliged. Obliged. Obliged.
B. Bora. Appearing on behalf of BKC.
In fact, pursuant to your lordship's last order, my lord, the petitioner, my lord, had contacted the Kasi University, my lord, and the last pay certificate was forwarded to the Assam University, my lord. But to my information, my lord, Assam University has not communicated. I don't know because my lord,
As per my instruction, Assam University has also written to the Mahatma Gandhi University, Kasi Vidyapedia Lordship. But till that, we have not received any communication from that Kasi Vidyapedia Lordship.
Petitioner, my lord, had conveyed it to my lord, the Assam University, my lord, and the tracking report shows, my lord, it was delivered, my lord, on, my lord, 18th of, my lord, this month, my lord. The last pay certificate, my lord, which he got from, my lord, the Kasi Vidyapit, my lord, that was delivered, my lord, to registered post. Lordship had permitted, my lord, the Vidyapit also, my lord, including, and also the petitioner, my lord, to submit the documents, my lord. And the Assam University was supposed to communicate with the university, my lord, the Kasi Vidyapit, my lord.
Three and four.
Mazumdar is appearing for 3 and 4, my lord. I think she is representing both of them, my lord. Okay.
কমিউনিকেশন আছে নেকি?
প্ৰথম বুলি কৰো নকয়
Malad, they may produce the communication because Malad, then we can know if there is anything else to be
Yes,
done.
Your Lordship.
Otherwise, it's vague, Malad.
Oblong.
Deputy Your Lordship.
May it please your lordship?
Lordship, we have received the instructions from the department. The son of the petitioner was not a permanent employee, so therefore pension cannot be granted to the petitioner. Lordship, I have it, but the print is actually not proper. I bought her. My lord, here, if I may, Your Lordship. Here, Your Lordship, respond number 1 and 2 is the veterinary department. Mrs. Kakoti is not well today, and her name is also not reflected as the standing council veterinary. She thought it Monday or.
Your Lordship, I kindly see order dated 28, 21, 8, 20. He is retired, Manor. January 22, nothing has been paid to her, my lord.
Oh,
No, let the concerned officer appear before the court, my lord. They are just not doing things rightly, my lord. She has retired in the month of January 22. Not even provisional
in the
pension has been
third
paid
page,
to her.
the communication. Third page.
This is 6/7/23.
let them cooperate and let the right proposal come.
Vikram Chaudhary was entrusted with this matter.
Nothing has been printed.
Yes, madam. After some time, madam.
May I please, my lord, petitioner is a fourth grade employee, my lord, Chokidar, my lord, and he has, due to his illness, he has taken leave, and on medical ground, he has submitted his bill, my lord, but the government has not paid the salary of 20 months, 7 days. Salary has not paid. He has submitted repeated representation, and that was forwarded and not paid, my lord. The government has given a reply, my lord, in this regard, my lord. Affidavit in oppositions, my lord. Paragraph. Affidavit in opposition. This case, the direction may given to the authority to submit his bails in proper manner. They have submitted the bill submitted without giving the counter sign.
basis.
Item 40, my lord. My lord, I am not feeling well, my lord. May I prepare for leaving the court, my lord?
Item 40, Lordship, I am appearing for respondent, my lord. wrongly listed in the admission column. Notice of date to issue.
It may be listed for motion, my lord. Deeply obliged, my lord.
Lordship, they had informed her for some formalities, but she wants the full pension. That has been communicated to me, Lordship. They have asked her to come to the office for some formalities, but she says she doesn't want the provisional pension. She wants the full pension, Lordship, now. Which, Lordship, I have come to know from my friend that the proposal that was submitted, there was some defect.
Now it has been corrected, my lord. Proposal has been corrected.
Again, the second resubmission also some mistake.
Let him correct it, my lord.
It will be done. Lordship, I will communicate this communication so that everything is done at time. And this is the instruction, Lordship.
It will come up next week, my lord. I will also ask why he has not gone for proposal.
Lordship, she has been paid LEB, GIS, and GPF sanction has been done 3-4 days, and it has been forwarded to the treasury. Lordship, by this time, it maybe has been credited to her.
Lordship may note that.
GPF. Lordship, last order, Lordship has.
It was
direct-
done.
directed
Respondent
to
number
India.
10. Newly.
We did. That's it.
Yes, listen. It will be done.
Your lordship has given a date 8/11.
Please, your lordship.
That has not been furnished. I have instructed them to communicate that. I've instructed them to communicate the inquiry report. My lord. They have not communicated. I've instructed them to communicate them. Now, my lord.
Paragraph has already come. Apart from that, my lord, my submission is this way.
Yes. Under the Khadi Board Act. Right, the two for yes, yes. For khadi garments and all for those. The Act is of 62. I believe. I don't remember. Act is of 62. Fab yes, yes, Fab India. I have. Yes, yes.
They have the outlets. They have the outlets. It's marginalized profit, well, it's a non-profit organization. Sorry. Man. This yes. Right. Basically, the Khadipur Mala is a non-profit organization. So, regarding on the salary is paid by the government manner in terms in aid manner. In grants in aid. Right. Yearly. Yearly they prepare a budget provision. The benefit of efficiency bar, crossing the efficiency bar. Yes, there are. Yes. There are. Basically, all the cases before the honorable court here, my lord, are regarding salary and allowances and pension, this stuff. That
My lord.
it was in a mess. The board was in a mess. What they do, my lord, they do not conduct any departmental inquiry. Yes. Other aspect, my lord, I yes. Other aspect, my lord, what I would like to place before the honorable court, my lord, on in a discussion made in the office of the chairman, my lord, it was discussed why we are not being. And basically the thing is that, my lord, the employees and for fresh employment they have to take the sanction of concurrence of the finance department. Yes, and so, my lord, now new employments are not coming up. Only the employees who were earlier appointed, and most of them, yes, they are freezing out. And they don't have that much of manpower or the strength that is required. That is also other aspect of the matter, my lord. Is there a yes. Artful. Puravi Dairy.
Yes.
In Assam, they are lacking. Basically, because of manpower, it's all. Regarding the clothes. Yeah, other they have their industries. They have yes, yes, but the honey and the mustard oil. Marketing aspect is also there. Now, basically, the board is facing the problem. The board is facing whether there are no new employments. The other the existing employees, they are all. I mean, what I mean to say, they are above 50s and the yes. Even it is very difficult for me to get an instruction from them. Anyways, on the other occasion, we file an affidavit. And there the remaining amount. My lord will make direct my lord within whatever. I'm sorry. The supplementary budget has to be given. Because I have stated in my affidavit, in our affidavit, there are other employees apart from the petitioner, who have the outstanding benefit of the efficiency crossing of the efficiency bar.
My lord, may I take little action? Payment will be lordship will pass on order. Here, my lord, lordship may peruse order 24/7/2023, whereby your lordship passed an order up to for regarding payable amount arrear increment after crossing the efficiency bar division from 2003 to July 2021. That particular period, then accordingly affidavit is filed, my lord. Now affidavit your lordship has gone through. Paragraph 5 it is that 4 it is that it is to be stated, it is stated that petitioner has filed the extended petition benefit claiming benefit of crossing the efficiency bar as per order dated so and so, so and so, so and so. That it is stated that with regard to the payment in connection with the benefit of crossing the efficiency, the account section of the board has made the calculation as under A, to be drawn 32,10,512, less already drawn 23,65,375, net pay 8,45,010, less reservation reserved for income tax 20% 1%, net payable 6,76,100. That though affidavit is not due before lordship, particularly going for our affidavit, it has been ordered that to show that, because after receiving that affidavit in opposition, I inquired from the clerk petitioner whether you have drawn or not. He has told that such type of big amount I have not drawn. Then lordship asked him the mode of payment. Now your lordship, then I say only not affidavit is required, but only instruction is required. Here today instruction has come, my lord. Lordship got it. Instruction you have seen not keep. Here, Krishnakanta Kakoti, two names are there here. Amount drawn with effect from 1/1/2006, 31/7/2001. that our claim is from 2003. There is not denial part. Then 32 lakhs. If we assume this 1 lakh from 1/1/2006 to 37, 32 lakhs, drawn 23 lakhs. It is again it has come. The last your Lord's word shall see the amount of rupees 23 lakh 65,000 here has been paid to him as monthly salary with effect from 1/1/2006 37/2020. Now, my lord, first and foremost thing, their calculation, own calculation, it's supposed to be from 2003, September 2003, but they are calculating from this 1/1/2006. 3 days not been considered. Second point, my lord, such a big amount, if 19 lakhs is paid, according to them, it is a monthly salary. It is a monthly salary. It is purely, it is refined head. It is a arrear salary. Cannot be, because whenever even we are drawing pension, even myself I'm drawing pension. Whenever main pension, when we will get the DA or any other arrear and things, it is come separated. It is always just come separated. It is not salary this much, your arrear is this much. The reply I'll file. Then I have yes, I have to say, my lord. The salary I'm drawing, my lord, there is no doubt in that. Yes, yes, they also calculated. By a monthly payment, monthly salary. No. But the problem is, sir, definitely I'll reply on one page reply to this. But a record will be revealing all everything, because record is with them. May I humble submission before Lordship only? This is Lordship my submission only. They have to, if they are clarifying me, okay, this much salary, okay, I'm admitting today, okay, salary, then at least let them show this, because they have records, my lord. I am only drawing salary. I can only write down only one thing, affidavit, but I'll write down, my lord. File affidavit, my lord. I have to file affidavit in this regard. 7 is not even complied so far. No, I cannot reply anything. No. Oh. Then I'll deny all these points. Okay, file that point. But regarding this point also, I clarify. Nothing that more than that. Because one of the problems is because one of the committee members suffered heart diseases. That's why he wants some amount immediately. There is a problem is coming. Tuesday, my lord. Wednesday, it should be by Monday. Lordship will be not sitting next division. next to next week, I'll be not available. Fourth, I'll buy 50, because on second my function is there. 50 will be listed, my lord. Okay. I'll short reply, one page. Oblige, my lord.
I'm deeply obliged.
May I please, Lordship. The petitioner retired from service on 31st of March 2022, my lord. Annexure C, page 23, my lord. Filed an application for release of DCRG, leave salary, GIS area, grade pay, and time scale. And among these, my lord, already DCRG, GIS, regular pension has been released. It's a leave salary, area grade 2 and time scale. Leave salary, area scale and time scale. তিনটা পয়েন্ট বাকিগুলো পাইছে
পেনশনটা পাইছে
পেনশন ডাইরেক্টর একটু লিখিস তোমার
প্রভিজনাল পাইছে
প্রভিজন তো পয়েন্ট থাকে নাকি এই ইয়াতে লিখিছে মানে এটা লিখিছে আপনার BCRG, GIS, regular pension from the director of pension. Here the five.
এটা তো ভেরি এটা আপনাদের ডিপার্টমেন্টে আমাকে তো অনলি হেলথ এন্ড
কি করতেছ
Yes, your lordship. Lordship, with regard to regular pension, it has been finalized on 20/12/2022. The soft copy has been sent to your mail, your lordship. Mail. Just now, your lordship. 2012/22. I'm for 5 and 6, your lordship. RT.
Oblige, Your Lordship.
My lord, leave salary kept pending before the instructor school. My lord. Leave level.
Next, my lord. And today we have been served with a copy of affidavit in opposition, my lord. We need to file a reply, my lord. 2 weeks time may be granted, my lord. Oblige, your lordship.
Meet with Lordship. When I withdrawing this petition.
Yeah, my lord. The petitioner, my lord, he earlier approached this honorable court, and the case of the petitioner was dismissed, my lord. And that fact has been suppressed by the petitioner in the present case. My lord.
C. Sharma, Lordship, for Dima Asaf.
And 1 and 5. Yes, Your Lord.
My lord, I have the order.
193 of 2016, madam.
This is the order.
One
196 of the 2016. My lord. 2016. Dismissed on my lord. 24/10/2017.
This matter pertains to non-payment of pensioner benefits and other service benefits.
Yes, Lordship. So according to the instruction, he was served the termination order after he have attained the superannuation age. That is, he was served at 69 in the age when he have reached the age of 69. And moreover, Lordship, if the appointment orders are looked into, he have only served for 2 years and 5 months, Lordship. They were appointed in a scheme, Lordship, for Decorative Textile Training Center. Lordship, we have prepared our affidavit and sent for vetting, Lordship. Sometime maybe given.
The respondent authorities to respondent authorities in Delhi. District Industry Center, NC Hills, Haflong, Dima Hatsoli, Haflong, NC Hills, Haflong, to file their affidavits in the matter, failing which the court shall consider to pass considering the consequential order. As notice in this case was issued to ABF on 12/12/2022.
Please, Your Lordship. Lordship, petitioner before Your Lordship is the eldest surviving wife, Your Lordship, and private respondent now is the second wife, and who is receiving the family pension since the death of my husband, Your Lordship, on 8/3/2021. Lordship, may kindly see page number 47. This is the
I am
article.
appearing on behalf of the private respondent number 9, Your Lordship. So some time may be given to file an affidavit, Your Lordship.
Lordship, they are getting family pension since 8/2021, Your Lordship.
2 weeks time may be given, Your Lordship.
It is admitted on the record that I am the eldest surviving wife, Your Lordship. Lordship, may peruse page number 19. There was a miscase for maintenance, Your Lordship, and that case, Your Lordship, has been decided there is no divorce. And accordingly, maintenance was also granted in favor of me, Your Lordship. Page number 19 and extra 1, Your Lordship. Relevant portion at page number 21. Your Lordship. Issue was framed in that regard also. Whether the second party divorced the first party.
We have filed a Wakalat number on 22nd of March 2023.
2 weeks time may be given, Your Lordship.
Sorry. Mr. D. Hussain.
R.A. Chaudhary.
Sorry, R.A. Chaudhary, counsel appearing for the petitioner. And Mr. N. Sharma, standing counsel, Department of School Education Elementary, for the respondent numbers 1, 2, 3, 1, 2, 4. 1, 3, 4. Mr. CS, who is appearing for the government? Government Advocate Assam, for the respondent number 2. And Mr. A. Saliha, standing counsel, AGA Assam, for respondent number 4. A. Saliha, standing counsel, finance, for the respondent number 8.
You may kindly grant
And
time, Your
Mr.
Lordship, because
U. Sharma, who is the
after notice, this matter is coming up for the first time today, Your Lordship.
respondent number 6 and 7.
By the court for the first time.
Matter pertains to family pension on the date of the husband of the petitioner, Matiur Rahman, was an assistant teacher in the Patharakanti Education Block, in the Provincial Elementary School, in the Patharakanti Education Block of District Karimganj. Who retired from service on 1/11/2012. Said Matiur Rahman expired on 08/03/2021. Petitioner claimed to be the first wife of Said Matiur Rahman, and in that regard, she has placed the copy of the order passed by the Judicial Magistrate First Class Karimganj on 29/07/2016 in Miss Case number 289/2014, filed by the petitioner for her maintenance from Said Matiur Rahman under Section 125 CRPC, being his wife. The while issuing notice, it is stated about in the letter, the petitioner submitted that after the death of her husband, such and such, the respondent authorities have paid the family pension to the respondent number 9, and she being the first wife, she is entitled for benefit of the pension, family pension, as established by law. While issuing notice on 10/02/2023, the court observed that the interim prayer shall be considered upon service of notice on the respondent number 9. The matter was fixed on 28/03/2023. The petitioner respondent number 9 entered appearance in this matter by filing Wakalatnama on 22/03/2023. Thereafter, this case was listed on 28/03/2023 and 30/08/2023. But no effective order was issued, as the matter could not be taken up for consideration. Your notice in this case was issued way back on 10/02/2023. The respondent authorities, including the respondent number 9, did not file their respective affidavits, considering the above, until further order of report. The respondent authorities, particularly the Treasury Officer, Karimganj, shall not release any family pension benefit to the respondent number 9, Rukia Begum, on the date of the husband of the petitioner as well as respondent number 9, Matiur Rahman, retired assistant.
May I submit your lordship?
In the meanwhile, the respondents shall file their respective affidavits.
Can it be
released on 15th of November.
Obliged.
Mr. Chaliha, immediately informed.
Well, non-payment of area salary, my lord, in the earlier occasion, instruction was sought for. Attorney was appeared.
We have received the instruction, Your Lordship.
To pay or not to pay?
Lordship, there is some, earlier she was working in girls semi school, Your Lordship.
Thereafter,
May I read it, Your Lordship?
just
With reference to the subject cited above, I have the honor to state that regarding salary, releasing of area salary in respect of Smriti Basanti Sinha in connections with WPC so and so, this director instructed the inspector of school KDC Karimganj to resubmit the area salary proposal with effect from 1/9/2012 to 28/12/2013, including non-dual certificate from the concerned treasury, white letter so and so dated 9/5/2023, Your Lordship. Accordingly, the concerned inspector of school white letter number so and so has informed this office that the period of aerial salary in question is beyond the jurisdiction of the Department of Secondary Education, Your Lordship. As the petitioner Sinha at that period was serving in girls' ME school, Patharkandi, before amalgamation with Pratapghar Public High School. As such, the inspector of school concerned has requested the district elementary education officer Karimganj to submit a detailed report about the admissibility of the area salary claimed by the petitioner, Your Lordship.
where is standing council elementary? It's a party here.
My lord.
So tell us what instructions you have. And if you haven't, then why you have not had? Tell us. As because the service of the petitioner has been amalgamated with a high school. So Director of Elementary Education is not required to serve any instruction.
No, my lord, we have not.
What happened? Why? Now just tell us, madam, when it was forwarded to the Director of Elementary Education.
21.
On 21/9, Your Lordship. 21.
Only on 21/9.
Yes, Your Lordship. 21 and 2023, Your Lordship. Yesterday, Your Lord.
Because of the case is fixed today. Anyway, now Mr. Vora has been communicated to you. Director of Secondary Education and Director of Elementary Education is very far. Wherever in LP school class 1 to is to taught the difference between Kanpur and Nagpur. You know that example?
Yes.
Where is Kanpur and Nagpur? Right? You know. So it is in the same distance. So not very far. So after vacation, you tell us the status.
My lord.
Right?
My lord.
Mr. Das. The area salary claimed by the petitioner is during the service, during her service while she was the headmistress of Patharkandi Girls Semi School. prior to the amalgamation of the said ME school with the Pratapgarh Public High School, Tinokhal, District Karimganj. As such, by communication dated 21/09/2023, the Director of Secondary Education Assam forwarded the matter to the Director of Elementary Education Assam. In view of the above, placed this matter on 22nd of November, enabling the Director of Elementary Education Assam, the respondent number 5, to apprise the court about the status of payment of arrear salary payable to the petitioner in as per her entitlement. It is to be noted here that notice in this case was issued on 17/03/2023.
Lord.
Yes, Mr. Mohan, what's the matter about?
The matter pertains to non-payment of the pension to the husband to the present petitioner in terms of the notification and compensation as your lord. Petitioner is the first wife of the deceased your lordship. The private respondent claiming as a second wife, and
Yes, your lordship. Some records were stored, your lordship, with regard to that next of kin certificate that was issued by the office of the deputy commissioner, your lordship. So they tried. They told that it is since it is with the Amtron, so they had sought for, your lordship. So in that case, your lordship, if your lordship places some accommodation. When I just when I say it is.
Yes, Mr. Mohan, tell us.
Lordship, the petitioner, husband was the teacher of 140 Chandra Sarkar MB School, and during his service, he died on 21/11/2021. Your Lordship. Leaving behind the
So, according to you,
Lordship,
you are the second wife.
I am the first wife, Your Lordship.
You are the first wife.
Lordship.
Who is the second wife?
Second wife is the private respondent, Your Lordship.
Now,
11.
Pensionary benefit given to whom?
Lordship, that has not been settled. They are in terms of the rule I am entitled being the first wife of the petitioner. But instead of that, they are going issue their notice, Your Lordship will find for regarding settlement page 37, Your Lordship. A notice was issued to us, and accordingly we have appeared before. Then after came to know about the report, Your Lordship, as circle officer, we have page 31.
You have your next of kin certificate.
Page 31.
So, yes, Mr. Deuri or Mr. Borao has not been released to the petitioner. Anyway, the other person is the second wife. She will have no claim. Why you have not released? You have seen, but the stand taken by the director is something different. The next of kin certificate at page 31 relates to the name of the petitioner.
Lordship.
Right? Lordship. It doesn't include the name of the respondent number 9. Now, anyway, respondent number 9 will not be entitled for any such pensionary benefit, being the second wife. Then why the pensionary benefit hasn't been released? Why? Now, since there is a dispute between first wife and second wife, both are claiming to be the wife of say Mr. Malo, Govinda Chandra Malo, will not be released. We have seen that. But it is the petitioner who is the first wife. Why the pension hasn't been released to her?
The rule is very clear, Your Lordship.
Why? Whether the director is keen to give it to the second wife? Definitely not. Cannot give, even if it is keen, because the rule is well settled. Then why it has not been released? After all, Director of Elementary Education has filed this affidavit, right? And what is her order after this hearing? That we have seen. What is her order? That's why I wanted to know. Filing an affidavit will not do it. You should have given direction. According to her, she has interfered. You should have given direction. Why she has not given that direction? Or the officers want the both the wives should run to their office every day for their pension. Something has to be there. It is a petitioner who is entitled for. Then Mr. Dekka is happy as long as the amount is not released to the
No, I am not happy, Lordship, because my son is also entitled in wave 143. Today I have filed it. And so far,
let us see your affidavit.
Today I have.
Let us see your record.
I have enclosed the rules also.
No. You check. এই উপৰটো এইটো তলৰটো নহয় মোৰ কপিটো ই লৈ গৈছে নাই আজি ফাইল কৰিছে The reason for non-furnishing the proposal is that because the petitioner is requested to furnish the next of kin certificate, including the son of the second wife. The annexer lordship, the affidavit filed by the respondent is clearly reflected. That is not done, lordship. But in view of rule, I am not conscious the so far the respondent number 9, my mother lordship, she is not entitled, but the son, he is entitled, lordship. He is a mentally retarded, lordship. I enclose the certificate.
Have you
also.
gone through the recent full bench decision? Have you gone through the recent full bench decision?
Yes, lordship. Yes.
What is that?
Appropriate form, lordship.
And what is that appropriate form?
The civil code, lordship. But so far the 143C, it clearly says for lifetime pension,
See,
lordship.
the family pension.
Yes.
The family pension is to be given to the first wife.
That's true, lordship. There is no lordship dispute,
Now,
lordship.
if the first wife doesn't share the family pension, then that question will come.
That is one aspect. But the other aspect
That is why that in that
but the
particular
rule
full bench,
309 rule says, lordship.
right?
The
Who
son
will
is
determine
entitled.
the share?
Now,
Who will determine the share?
here, lordship, without disclosing the facts of this son of the second wife, the petitioner has applied and approached this honorable court. Because of this, next second.
First of all, second wife has no right.
No right, lordship.
Second wife is claiming for her son.
Yes. Actually, I am not aware, lordship. When they have filed this writ petition, we came to know, lordship, they have shown the
Unless-
next of kin certificate without showing the name of the.
Unless the second wife shows that the amount of family pension given to the petitioner
Oh, that is up to the
has not
authority.
been shared with the son of the
It is up to the
respondent number
authority,
9.
lordship, because I am lordship before the lordship judge. So far, my son is concerned, he is also entitled. So let the authority
Who has
decide.
denied? Only when the petitioner will deny.
No,
then the
denied, but they
question-
have not disclosed. That is why in my affidavit, I have said that
Question
he is
of
a
dis-
necessary party.
The question
The-
of disclosing will not come because the next of kin certificate cannot be given to somebody else, the illegitimate child, unless been claimed.
That is why the
Now-
case 37.
You have claimed, fine, good.
Yes. And the application also is pending before the deputy commissioner also. That is also
Lordship,
pending. Because this rule says, after the proposal lordship was submitted,
Now,
the
is it
deputy commissioner
whether-
concerned with.
That's why tell us, Mr. Dekha,
Lord.
with your experience in the bar, whether next of kin certificate can be issued to an illegitimate wife. Whether any next of kin certificate can be given by the deputy commissioner to an illegitimate wife.
That called by the so far the petitioner.
Tell us first. Tell us first, if it is possible, you say yes. If it is not possible, say no. And if it is yes, why and how? And no is no. You need not
Here
explain.
also I am concerned only for my son, Lord.
Then,
Not for other.
then that
Because
thing
he
we
is
have to
entitled.
claim first.
Yes, I can. That is why I file application before the
Now
authority.
that will come when.
That this was filed, Lordship, on.
Now show us from the pension rules that the share has to be given by the.
The pension is not speak about the share, but so far the entitlement,
That
Lordship.
is why-
143C is
and
clear, Lordship.
That is why the full bench have considered that aspect. Read the last two paragraphs. If a family pension is given, it means the head of the family will look after. You will get that compassionate family pension scheme of the finance department. The last two paragraphs deal with this. The compassionate family pension scheme. I think it is annexed in the writ petition. Mr. Lahan, have you annexed a copy of the compassionate family pension?
Yes, page 33.
It is there somewhere, very well defined. Mr. Deka.
Lordship. Page 34 is the.
Come to page number 34, clause 5.10.
Yes, on receipt of such complaint from them, the competent authority will issue orders apportioning the compensation.
No, 5.10.
Yes, it is also provided that
Hmm.
if the parents or other eligible family members are not looked after by the compassionate family pensioner, then next comma, on receipt of such complaint from them, the competent authority will issue orders apportioning the compassionate family pension appropriately among the other eligible family members. Now I approach the authority.
Now, when was the family
The
pension
deputy,
paid?
before the deputy commissioner.
When the family pension has been paid? Has
It is
been
not paid.
Now the issue has, now you are saying, as the next of kin certificate, the name of your son is not there. First of all, you have to establish that you are the second wife, right? Illegitimate, legitimate, that will different come to later. The petitioner has not yet been paid the family pension.
Because the lordship kindly come to the page
See,
and
it should have been the other way, right? If the family pension is paid, you raise the dispute before the authority concerned, share hasn't been given to your son, then you do the needful.
so before that I have already in view of this rule lordship
So
before
that itself indicates, that is why I'm telling you, in the full bench decision has specifically mentioned, this is under the scheme, right? And that's in the pension rules. There it has been provided. Approach the appropriate forum.
Irritable 160 obligatory.
Mr. Bora, immediately submit the pension proposal. Immediately submit the pension proposal.
My application is
No point
also
of delaying the matter. Thereafter, if Mr. Deka has certain objections, he can always approach you or the appropriate forum.
the application is filed before deputy
See,
commissioner.
whether look after or not look after, who will decide? Read court cannot decide. There has to be an evidence. Evidence can be considered only by the civil court. Let us know by the next date.
Lord.
What's the Thank you. One more.
Obliged.
List after entering for the vacation.
Item 31.
You have filed your affidavit. What is your stand? Entitled or not entitled?
Lordship, in this regard, I have filed my reply, Lordship, and this honorable court also.
Just a minute, just.
Lordship, in a similar situated matter, which was dealt by this honorable court, that person was initially suspended from service in the year 1994. Thereafter, he got retirement in the year 2020 and he approached before this honorable court in the year 2022. The honorable court was observed that, Lordship, since the entitlement of subsistence allowance that cannot put under question, and the state respondent is duty bound to pay the subsistence allowance within a period of 45 days. Accordingly,
Council,
yes, Your Lordship.
please show us the particular application on
Lordship.
which you have submitted for the authority concerned for your subsistence allowance.
Lordship,
and
Your
that you
Lordship.
were not engaged in any other activity.
Yes, Your Lordship will
And
find
when
a
it
page
was
number.
received, when it was received by the authority concerned, do you acknowledge? Show us.
Your Lordship will find at page number 51, Lordship, in my affidavit in reply, Lordship.
51.
Yes, Your Lordship.
When it was received by the authority concerned.
Lordship, that was file on 18/11/2002 and 11/2002.
18/11/2002.
And
Where from you
thereafter,
are
page
seeing-
number 53 is 3rd of February 2005. Lordship.
Show us, how do you know that? Where is the number, receipt number?
Lordship, there is no receipt number, but their seal and signature is there.
That is
Lordship.
always manageable. Hundreds and thousands of seal you can make.
That whatever
Whereas
may
there
be,
is always a register in each of the office.
the Lordship, whatever may be, the Honorable Supreme
Not
Court as
satisfied.
well, and
That
also
kind of signature, without signature and number, please don't bring it to the notice of at least to this court. We have seen.
Your
If
Lordship,
you want, I can prepare a seal by tomorrow.
no, Your Lordship will find
Will not
at
extend to
page
that
number 20. Your Lordship will find in my writ petition at page number,
When you were
Lordship,
suspended-
27.
When you were suspended,
Lordship, I have been put under suspension due to unauthorized absence when I was.
by which order you have been suspended?
Lordship, page number 25. Your Lordship will find
Kindly give us that. We have been looking on the page only.
Three-
Give us-
3/6/1995.
Now, on 3/6/1995, we have been suspended.
Yes, Your Lordship.
And you said that you have submitted your application for your subsistence allowance as per your additional affidavit
No, because
on
because
18/11/2002.
this is true, but Your Lordship will find it in my suspension order that it is further ordered that during the period of suspension, Muhammad Abu Tahir Ahmed, UD assistant, will be paid subsistence allowance. It is a order of the authority, Lordship. Because it is similar to my suspension, Lordship. One hand I have been put under suspension, other hand they have directed to release my Lordship
Tell us
subsistence allowance.
to receive subsistence allowance, what is the rule say?
Rule
What is
says,
the rule
Lordship,
say?
rule, Your Lordship will find at page number FRSR 53. Your Lordship
Tell
will find.
us what it says.
FRSR 53(2), in case of Lordship, other government employee, in case of Lordship, one is for commission officer of the Indian Medical Department and or a warrant officer, and the 2 is Lordship in case of other government servant. A subsistence allowance at an amount equal to the leave salary which the government servant would have drawn if he had been on leave or on half average pay or on half pay, and in addition dearness allowance based on such leave salary, provided that where the period of suspension exceeds 3 months, the authority which made or is deemed to have made the order of suspension shall be competent to vary the amount of the subsistence allowance for any period subsequent to the period of past 3 months as follows, Lordship.
Then what is the requirement?
Your Lordship will subsequently find, Lordship, the amount of subsistence allowance may be increased by a suitable amount not exceeding 50% of the subsistence allowance admissible during the period of past 3 months. If, in the opinion of the said authority, the period of suspension has been prolonged for reasons to be recorded in writing, not directly attributable to the government servant. But in this case, Your Lordship will find
Mr. Counsel,
till
tell
that
us.
no so-cause notice has been issued, Lordship.
Now just tell us It has been supplemented further by the government order. Are you aware of that?
Lordship,
It has been supplemented further by the government order. Are you aware of that?
75 after 3 months, 75.
That is always there.
Yes, Your Lordship.
When you are in suspension, the first condition, you should not be indulged in any other activity like getting any benefit.
Yes, Your Lordship. But
Right.
it does not imply that.
Listen.
Uh,
Have patience.
Yes, Your Lordship.
4:30, we are having patience from 10:15.
Yes,
You should have patience.
I'm sorry, Lordship.
You are young, I can understand. For that purpose, the concerned incumbent is required to submit an application for drawal of his suspension allowance, along with a certificate that he has not been engaged in any other way to earn any benefit.
Yes,
Have
true.
you submitted any such
Yes,
application
true.
along with that application?
Yes, true. But my humble
It
submission.
is not automatic.
No,
It has
yes, Your Lordship.
both ways tendency.
But
Before that, just tell us whether the petitioner at any point of time
yes, Your Lordship.
prior to 2002, after his placing him under suspension,
Then Lordship, Your Lordship may kindly fix on Wednesday or Monday. I will inform
you
Your
file your
Lordship.
additional affidavit
Yes, Your
showing that you have submitted an
Only
application.
my humble submission is before Honorable Court
You are
is
not
that,
denying
Lordship.
that you are not entitled for.
Yes, my humble submission is
If
that.
you can
Lordship,
show that during that period, right?
Yes,
During that period, you were not engaged otherwise in any activity for gaining any financial benefit.
I have given Lordship this.
You submitted, you have to submit it before the
I have not
authority.
engaged.
You are appointing authority, the authority who terminated your service or who placed you under suspension.
Yes, Lordship, I have.
Let us see that.
In the last occasion when this matter was discussed before this Honorable Court, in page
Bring it
number
to the notice of the court by filing an
page number
additional-
55, Your Lordship will
Page
find.
number 55.
Yes, Your Lordship. After when the in the last occasion when this matter was discussed before this Honorable Court, your Honorable Court also expressed the opinion after taking up this matter that Supreme Court, Honorable Supreme Court by direction, Lordship, that state cannot derail from their responsibility for payment of
You
subsistence.
get large
allowance.
number of decisions, right?
Yes, Your Lordship.
But thing is
That
this,
was relied by this
in fact,
Honorable
that,
Court.
that was by this
That's
court
your
has
Lordship.
explained.
Yes,
But
sir.
for that purpose, you have to submit that application along with that certificate that you are not engaged in any other activities earning any
Lordship,
benefit.
I have written to the Lordship authority that on 28 2023 that I have not
A
engaged.
self-certificate has to be issued and submitted before the authority for that purpose. Show it. If you have submitted it, we'll pass the order.
In page number
Right.
55, since I have not engaged in any way, Lordship, therefore I have written.
You
to
know
the-
better.
Yes, sir, Lordship.
Excepting you, nobody knows better, right? Whether you
Yes,
are
sir.
engaged or not
Therefore,
engaged.
Lordship, I have written to the authority on page number 55.
Show your certificate,
Yeah,
self-style certificate. We'll consider.
Lordship, page number 55.
You submit your additional affidavit in that figure that
Lordship,
you are not
yeah,
engaged
Lordship, may
within
kindly
that period.
peruse page number 55 for a
We have
time.
seen that, but
Yes,
that
sir.
is without any seal and signature. That's in vernacular. That's in, of course, that in English
number
55. We have
56.
just seen. It's before us. Page number 55.
Yes, sir, Lordship. There is a translated portion and page number 56 is
This is
article.
translated in vernacular. It is in page 56.
Yes, sir, Lordship.
Right. Where is this certificate? Where is the certificate?
Certificate.
There is a format for that purpose. Find out.
Yes, sir, Lordship. I will find. Lordship, your Lordship may kindly fix this matter because the wife of the Lordship, this petitioner,
Definitely.
has lost his
Now tell us,
her
when will
both
you,
kidneys, Lordship. Therefore, she is
when will
under
you file your
in
additional
critical
affidavit?
condition, Lordship. By Monday, I will Tuesday, I will file. Thereafter, your Lordship may kindly taken up this matter next week, Lordship.
It is said that the petitioner shall file an additional affidavit in this matter. Was the claim of his subsistence allowance with himself certificate along with the application self-certificate submitted before the authority concerned for his subsistence allowance before the authority concerned about listening before the authority concerned I, the Director of Elementary Education Assam, who placed him under suspension from service on 03/06/1995 under sub-rule 1 of Rule 6 of the Assam Services Disciplinary Appeal Rules 1960. Such additional affidavit shall be filed by the petitioner with the due acknowledgement letter of the submitted before the order with due acknowledgement. Such affidavit shall be filed by the additional affidavit shall be filed by the petitioner on or before 28th of September. Placed on 4th of October.
Item number 54, can you take this matter on Monday, Lordship? Very urgent. Petitioner not allowed to sign the teacher attendance register.
Tuesday.
Item 44, my lord, was upgraded, my lord. Lord, may I have a date, my lord?